And the UGC guideline was taken into account, while the National Institute of Technology, is governed by AICTE. So these are certain relevant aspects of the matter. Now, Lordship, this impugn order is at page number 321. Now, the relevant portion is at 340, Lordship, of this particular impugn order. Paragraph number 24.
Yes.
At this stage, married Lordship, this paragraph number 24. At this stage, it may be relevant herein to take note of that the requirement of eligibility for placement to the senior scale through a procedure of selection. Clause 720 of the UGC notification on revision of pay scale, minimum qualification for appointment of teachers in universities, colleges, and other measures for the maintenance of standards 1998 deals with the lecturer senior scale. The said clause being relevant is quoted herein below. Lecturer senior scale, a lecturer will be eligible for placement in a senior scale through a procedure of selection if she or he has completed 6 years of service after regular appointment with relaxation of 1 year and 2 years respectively for those with MPhil and PhD, participated in one orientation course and one refresher course of approved duration, or engage in other appropriate counting education programs of comparable quality as may be specified or approved by the University Grants Commission. Those with PhD degree would be exempted from one refresher course and consistently satisfactory performance appraisal report. From the above quoted clause, it would therefore appear that for a lecturer to be eligible for placement in the senior scale through a procedure of selection, the said lecturer has to comply with the 3 requirements enumerated in subclause 1, 2, and 3. A perusal of clause 1 would show that the lecturer should complete 6 years of service after regular appointment, with relaxation of 1 and 2 years respectively for those with MPhil and PhD. As the petitioner had MPhil, the period of service would be 5 years. And taking into account the judgment of this court dated 3/12/2017, which held that the service rendered by the petitioner as a system program has to be taken as equivalent to the post of lecturer. The said period of 5 years would have completed on 3/10/2001. Now, coming to the subclause 2, it shows that the lecturer to be eligible for placement to the senior scale has to participate in one orientation course and one refresher course of approved duration, or engage in other appropriate continuing education program of comparable quality as may be specified or approved by the University Grants Commission, and those with PhD degree would be exempted from the refresher from one refresher course. In the observation made in the minutes dated 27/4/2017, no specific objection has been raised as regards non-compliance to subclause 2, save and except the petitioner did not attend 4 weeks summer winter school and he attended only 19 days as on 3/10/2001. At this stage, it may also be relevant to take note of clause 7.7.0, which stipulates the requirement of participation in Oriental oblique refresher course of this summer institution, each of at least 3 to 4 weeks duration. The said clause has been enumerated here in below. Now, paragraph number 28, Lordship. From a perusal of the said clause, it would show that whenever the requirement of orientation refresher course has remained incomplete, the promotion would not be held up, but these must be completed by the year 2000. Therefore, it would be seen that promotion cannot be held up whenever the requirement of orientation refresher course has remained incomplete, and therefore the second ground so taken in their observation dated 27/4/2017 cannot be said to be a justifiable or plausible ground. Further to that, it being the specific case of the petitioner, that on the date of interview, the petitioner had satisfied the requisite eligibility criteria, which have not been denied by the respondents. Now, the third observation is there, but pausing for a moment, Lordship, the impugn order which has been put to challenge before the Honorable High Court in the writ petition, I'm just referring to that particular order. If your Lordship kindly see that particular order. This particular order in our affidavit in opposition, it is at page number 191, Lordship. It's minutes of the meeting. It is at page number 314. 314.
Yes.
314. Married Lordship.
Yes.
In pursuance of the committee constituted by the BOG in the 53rd meeting and corresponding office order issued by number such and such dated 24 2017 to review the issue of considering the period of service rendered by Dr. A. Bhattacharya, Assistant Professor, CSE Department, as System Programmer for his placement as lecturer senior scale, the committee met on 27/4/2017 in New Guest House, NIT Silchar. The observation of the committee with regard to the above matter is furnished below. For the post of lecturer in Computer Science Engineering Department, the minimum qualification was first class BE BTech. It was a teaching academic post guided by AICT norms. Graduation in specific branch of engineering was required as minimum eligibility criteria. For the post of system programmer, the minimum qualification was first class B in CSE or ECE or E or MSc in maths. It is non-teaching post. So this is vital lordship. One is teaching and the other is a non-teaching post, non-academic, and not guided by AICTE norms. As such, all the eligible candidates for system programmer position are not eligible for lecturer position in CEC. The eligibility criteria, pay scale, job requirements, etc. for the post of system programmer were decided by the Department of CEC REC Silchar. This post is not same as that of the lecturer. These vital two aspects of the matter lordship has not been dealt by the in this impugn order lordship. One is academic, one is non-academic. The petitioner initially joined this institute as a system programmer. Subsequently, another advertisement. Again, he participated and he joined then as a lecturer. So this is academic and non-academic. And this particular career advancement scheme is specifically for a teaching post. This is not for a non-teaching post. And the system programmer, which he had rendered for a certain period of time, that was also to be counted because this is absolutely a non-teaching post. And teaching post and non-teaching post cannot be clubbed together. So these two relevant aspects of the minutes has not been dealt with by this honorable court while passing this impugn order. And now the operative portion of the minute, it is at page number 37,
Which?
page number 315. Following observations are made. Why his case was not considered? Considering MCSE degree of Dr. A. Bhattacharya, minimum experience required for placing out to lecturer senior skill was 5 years. It may be mentioned that Dr. Bhattacharya worked as system programmer from 3/1/1996 to 22/1/1999 and subsequently joined as lecturer on 23/12/1999. He was granted EOL without pay from 1/1/1997 to 15/3/1999 for prosecuting higher study. That is observed that Dr. Bhattacharya actually served the institute as lecturer for a period of 1 year, 9 months. 12 days only as on 31/10/2001, and it was also on probation. Dr. Bhattacharya did not attend 4 week summer. Just now I have read out lordship the three requirements of this applicability of the CS scheme. Dr. Bhattacharya did not attend 4 week summer winter school. He attended only 19 days as on 3/10/2001. Dr. Bhattacharya's performance was not satisfactory as his probation was extended for another 1 year. So these are the three vital aspects of the matter was taken into account while non-considering the case of the petitioner for promotion under CAS scheme. And now, what is that CAS scheme, lordship? Now, lordship, this CAS scheme, it is in page number 119.
1/8.
How much can line?
Into 1/8.
Oh, wait, 119. 119, lordship.
Yes.
Now, the headline is that career advancement scheme of teachers. So this is important lordship, the career advancement scheme of teachers of degree level technical institutions. So it is very specific that this particular scheme, CS scheme is applicable to teachers of degree level technical institutions. Now, with regard to that, now the lecturer senior skill. Now, these aspects are mentioned here. The promotion under career advancement scheme will follow the guidelines given below. All the promotion in career advancement will be on institute basis, and therefore, the work allocation, teaching load, etc., will remain the same after promotion. Now, the general and the lecturer senior skill. A lecturer will be eligible for placement in a senior skill through a procedure of selection if she has. So, these are the things that have been referred to in the impugn order, Lordship. Now, this particular scheme, the career advancement scheme, is basically for teachers. And the petitioner who is asking for the consideration of that particular period, it was a non-academic and non-teaching post. And that relevant aspect of the matter we have specifically mentioned in our affidavit in opposition also, Lordship. In the subsequent writ petition. If your Lordship kindly see the affidavit in opposition, it is in page number 250. And page number 252, Lordship, paragraph number 6. 252, Lordship. Paragraph number 6. Starting from paragraph number 5. 251. 251, Lordship.
Yes.
That with regard to the statements made in paragraph number 5 of the writ petition, the answering respondents beg to state that the petitioner was selected as lecturer on 23/12/1999, which is a fresh appointment. This is important, Lordship, which is a fresh appointment in a new post for him. Therefore, the new service of the petitioner as lecturer has been counted from 23/12/1999, and all the entitlements were granted to him without any discrimination. Now, the next paragraph, that with regard to the statements made in paragraph number 6 of the writ petition, the answering respondent beg to state that the qualification for system programmer and lecturer are not equivalent as contended by the writ petitioner, since the post of system programmer is a non-teaching cadre and the post of lecturer is a teaching cadre, and there is no link between the two cadres lines, even though scales are equivalent. It is pertinent to mention here that the petitioner has failed to make out any case whatsoever to substitute the fact that the post of system programmer is equivalent to the post of lecturer, and because of that, he applied for the post of lecturer as a fresh candidate, and accordingly he was selected. The petitioner, on being selected, joined the post as lecturer, which is a fresh appointment in a new post for him, the petitioner having subjective knowledge of such service conditions. So this is the thing, Lordship. Absolutely, it's a teaching and non-teaching post, academic and non-academic post. And now how it has been clubbed together, how it has been taken into account. This is based on the UGC guideline.
Who is the guideline?
Yes, Lordship. UGC guideline, it is there at page number 50. UGC notification on revision of pay scale.
Page 50.
Page 50, Lordship.
Yes.
Page 50, this page number 56, 7.2.0. Lecturer senior scale. And this is the same thing, completed 6 years of service after regular appointment. All these things are there. Participation in one orientation, consistency, satisfactory performance appraisal report. Now the counting of past service, it is there in page number 59. Ashok, got it?
Yes.
Page number 59, this is 8.0. Previous service without any break as a lecturer or equivalent in a university, college, national laboratory, other scientific organization, CSR, ICR, DRDO, UGC, research scientist should be counted for placement of lecturer in senior skill selection grade, provided that the post was in an equivalent grade scale of pay as the post of the lecturer. The qualification for the post were not lower than the qualification prescribed by the UGC. The candidate, the appointment was not ad hoc or in a leave vacancy as less than 1 year duration, ad hoc service or more than 1 year. These are the conditions. So this particular aspect of the matter, the counting of past service, was taken into account for considering that these two teaching and non-teaching or academic and non-academic can be clubbed together. But this, how this UGC guideline, because we have taken a specific stand in our affidavit opposition also, Lordship. This institute is governed by AICTE norms. and how this UGC guideline is applicable with regard to the past service, and how these two particular posts can be constituted as the equivalent to. And there is no reflection with regard to that in the impugned order, Lordship. And there is a reason why I prefer this appeal, because here in this case, Lordship, I'm just going back to this, the impugned order, the operative portion, how it has been taken together, and how this honorable court, the honorable single judge, has passed this order. Lordship, I'm referring to page number 345, paragraph number 31. Paragraph number 31. 345, Lordship.
Yes.
From the above, it would be seen that the observation made in the minutes of the meeting held on 27/4/2017 to deny the benefit to the petitioner were on reasons which were never raised in the previous proceeding. The principle of constructive res judicata duly applies to proceeding under Article 226 of the Constitution, for which the grounds cannot be taken as a later stage, pursuant to the specific direction being given by the court to reconsider the case of the petitioner in the light of the observation made in the judgment and order dated such and such. Even otherwise, also, these grounds cannot be reasonable or plausible grounds, as already mentioned herein above, for denying the benefit to the petitioner. In the opinion of this court, the observations so made in the minutes of the meeting and the conclusion, therefore, are acts done wrongfully and willfully without reasonable or probable clause, and therefore would mean exercise of power for purposes foreign to those for which in law it was intended. At this stage, it will be relevant to refer to a recent judgment of the Supreme Court, such and such, reporting such and such, the relevant paragraph, such and such. Now, paragraph number 32, page 348. From the above observation, of the Supreme Court, and taking into account the findings arrived at herein above, it will be seen that the petitioner has been deprived of the benefit of the order dated 3/2017, passed in WPC number 1969/2014, on factors not germane, for which the minutes of the meeting dated 27/7/2017 and the consequential order suffers from malice in law, for which the said would not be sustainable in law. Under such circumstances, the question therefore arises to what direction can be this court path. It is no longer eccentric that this court in exercise of its jurisdiction does not normally direct authorities to act in a particular manner. Aware of this legal proposition, this court in its judgment and order dated such and such refrained from directing the respondents to grant the benefit of lecturer, but directed reconsideration of the case of the petitioner in the light of the observations so made. In spite of the said direction being given on the basis of the finding, observation made by this court, the respondents, in order to nullify the rejection passed by this court, have rejected the case of the petitioner on grounds which are not germane to the issue and which were not also barred by constructive res judicata. Now, it's a case of constructive res judicata. Now, the fact is that, Lordship, this writ petition, prior to this particular writ petition, had approached this honorable court. That was the first writ petition. In this first writ petition, Lordship, there is a direction of this honorable court. I'm just referring to that particular order. It is that page number, Lordship.
195.
भूला सर बेटा
238.
Yes, Lordship, I've got it. I could just now. Yes, it is there at page number 284. No, no.
Finding 52.
240. Yes, Lordship. It's a 242. I'm sorry, Lordship. It's a 242. Starting from page number 241. Submission made by the learned counsel for the parties. 241, Lordship. Submission made by the learned counsel for the parties have been duly considered. Short point for consideration is whether the previous service rendered by the petitioner in the post of system programmer, computer science, and engineering should be taken into account for placement of the petitioner's lecturer senior scale. In the categorical stand of the petitioner in the post of system programmer and lecturer in computer science and engineering are equivalent posts requiring identical qualification and having the same pay scale. It is also the case of the petitioner that as per advertisement for the post of system programmer, the selected candidate was required to conduct teaching as and when requirement arose. Though these averment of the petitioner had not been specifically denied by the answering respondent in paragraph 6 of the counter affidavit, all that has been stated is that there are two divisions in the NIT, one teaching and another non-teaching. The teaching division comprises of lecturer, etc., whereas non-teaching division comprises of system programmer, etc. Job requirement in both the divisions are different. Therefore, petitioner cannot claim service benefit of system programmer as there is no link of nexus between the two. I am afraid the view taken by the respondent is too narrow and technical, and if accepted, would defeat the objective behind the scheme itself, which is intended to advance the career prospect of the faculty. As already noted above, the effective date of grant of CS benefit is the date when the candidate becomes eligible. In the case of a candidate having MTech, he becomes eligible for rendering minimum service of 5 years. In the UGC clarificatory guidelines, as alluded to herein above, counting of per service is permissible provided there is no break between the two services, and the previous service was in an equivalent post. Equivalence has been defined as carrying the same scale of pay and qualification and not being lower than the qualification prescribed for the post of lecturer. From a careful analysis of the materials on record, the assertion of the petitioner that the post of system programmer is equivalent to the post of lecturer in computer science and engineering has sufficient merit and cannot be wished away. Answering respondents have not been able to disclose the assertion. This aspect of the matter appears to have been overlooked by the selection committee in its meeting held on 17/1/2014. Viewed in the above context, submission made by Dr. Sarkar, Learned Counsel for the petitioner has sufficient force and merit acceptance. In view of the above discussion, respondent number 1 and 2 are directed to consider the case of the petitioner. So that was the direction, Lordship. The finding with regard to this fact, there is no finding, because what this honorable court has come to a conclusion is with regard to the fact that since they are having the eligibility criteria, they're fulfilling the eligibility criteria, then it becomes an equivalent post. But fact remains that the career advancement scheme is specifically applicable to teachers during the relevant period of time for consideration of promotion. But the period claimed by the petitioner for counting, that particular period of time, he was not discharging his duty as an academician. It was a completely non-academic post. So these relevant aspect, this is a relevant aspect of the matter for applicability of the CAS has not been taken into account. I've just now read out this provision, this interpretation of the CS in the CS itself. It has been specifically mentioned that it is for the teachers, the career advancement scheme for the teachers. How this career advancement scheme for the teachers is applicable to a person who did not serve as a teacher during the relevant period of time?
We can admit it requires some consideration.
My lord, my first submission would be the appeal does not have any legs to stand. The specific finding of this honorable court in 2014, writ petition 1969 of 2014 is that the post of assistant programmer and the post of lecturer are analogous post, equivalent post. And therefore, the past service rendered in the post of system programmer has to be taken into account while considering his placement in the lecturer senior scale. That finding has attained finality. And the honorable single judge in the judgment has categorically given a finding that since the direction was given to the authorities to reconsider my case in the light of the observations given, so therefore they did not have any room left to come to a different kind of a finding. Your lordship will kindly come to the finding of the learned single judge at page 335, paragraph 18. They're repeating the same issue again and again, despite the fact that there has been a clear finding of this honorable court, and that finding has attained finality. They preferred an appeal, that appeal was dismissed. Appeal against the order of the single judge in 1969 of 2014. They preferred an appeal, that appeal was dismissed, although it was on the ground of a limitation, but the observation made by the division bench as regards the tenability of the grounds are also relevant, which was placed before the honorable single judge in the judgment, in the proceeding which is impugned now. Your lordship will kindly come to paragraph 18 at page 335. This court white judgment and order dated so-and-so in WPC number so-and-so had come to a categorical finding that the post of system programmer is equivalent to the post of lecturer in computer science and engineering. And it further observed that the said aspect of the matter was overlooked by the selection committee in its meeting held on 17/1/2014. Relevant portion of the said judgment have already been quoted here in above. It transpires from the judgment as well as the pleadings in the earlier round of litigation that the same question has been again raised in the instant proceedings by the respondent, which had been specifically dealt with by this court in the said judgment dated 3rd of February 2017. Now the question therefore arises as to whether the direction to the respondents number 1 and 2 to reconsider the case of the petitioner for placement as lecturer senior scale with effect from 31/10/2001 and to grant all consequential benefits. Was it a mere direction to consider the case of the petitioner, or was it a mandamus directing the respondents to consider the case of the petitioner in the light of the observations made in the judgment? At this stage, it may also be relevant to mention here that feeling aggrieved and dissatisfied, the respondents number 1 and 2 had preferred a writ appeal against the judgment and order dated so-and-so. There being a delay, an application for condonation of delay was also filed, which was registered and number as so-and-so. Division bench of this court, by an order dated so-and-so, had dismissed the said application seeking condonation of delay. Thereby, in effect, the writ appeal so preferred was dismissed in as time barred. It has been stated at the bar that no further appeal or proceedings was preferred against the said order dated so-and-so. Consequently, the findings so arrived at in the judgment and order dated so-and-so has attained finality. Now, coming to the question so posed as to whether the said direction passed in so-and-so is mere direction to consider keeping all the points open, or was it a direction to consider in the light of the observations made by this honorable court? The answer to the said query can be found in the judgment of the Supreme Court rendered in the case of so-and-so. The relevant portion is quoted. Now, paragraph 16 of that particular judgment. The high courts also direct the authorities to consider in a different category of cases where an authority vested with the power to decide a matter fails to do so in spite of a request. The person aggrieved approaches the high court in which, in exercise of the power of judicial review, directs the authority to consider and decide the matter. In such cases, while exercising the power of judicial review, the high court directs consideration without examining the facts or the legal questions involved and without recording any finding on the issues. The High Court may also direct the authority to consider afresh where the authority had decided a matter without considering the relevant facts and circumstances, or by taking extraneous or relevant matters into consideration. In such cases also, the High Court may not examine the validity or tenability of the claim on merits, but require the authority to do so. Where the High Court finds that the decision-making process erroneous and records its finding as to the manner in which the decision should be made, and then directs the authority to consider the matter, the authority will have to consider and decide the matter in the light of the findings, observations of the court. But where the court, without recording any findings or without expressing any view, merely directs the authority to consider the matter, the authority will have to consider the matter in accordance with law, with reference to the facts and circumstances of the case, its power not being circumscribed by any observations or finding of the court. We may also note that sometimes the High Court dispose of the matter merely with a direction to the authority to consider the matter without examining the issue raised, even though the facts necessary to decide the correctness of the order are available. Neither pressure of work nor the complexity of the issue can be a reason for the court to avoid deciding the issue which requires to be decided and disposing of the matter with a direction to consider the matter afresh. From a reading of the above quoted paragraphs of the judgment, it would show that a court exercising jurisdiction under Article 226 of the Constitution may make a direction to consider without going into the merits of the case, and in that circumstances, the authority will have to consider the matter in accordance with law, with reference to the facts and circumstances of the case, and its power not being circumscribed by any observations or findings of the court. However, this is important below. If the High Court, while exercising jurisdiction under 226 of the Constitution, finds that the decision-making process erroneous and records its finding as to manner in which the decision should have been made, and then directs the authority to consider the matter, the authority will have to consider and decide the matter in the light of its finding and observation of the court. In the previous round of litigation, the categorical finding of the Honorable Court was that the two posts are equivalent and he is entitled to count the past service rendered in the post of system programmer. And necessarily, my lord, the direction was to, in the light of that observation, the direction was, I'm going back to page 242. In view of the above discussion, the respondents number 1 and 2 are directed to reconsider the case of the petitioner for placement as senior lecturer. This was very specific. So no discretion was left with the authorities to come to a finding in disregard to the findings given by the honorable court. And that is the reason, my lord, the honorable single judge in the judgment impugned has specifically referred to this aspect of the matter, that when the decision has been given vis-a-vis the issue, because their basic issue is that since I was a system programmer at the beginning, so my service rendered in that particular post would not count towards the period of service countable for the post of for placement to the post of senior lecturer. And the categorical finding of the honorable court in the previous round of litigation was that it has to be counted. So they cannot deviate from it, nor can they take any other ground, because that will be barred by constructive res judicata. That has been stated by the honorable court now. Since the grounds which were available to them or might have been available to them, but they did not take, they cannot take those grounds now in the subsequent round of litigation. That will be barred by constructive res judicata. And the kindly consider the contention which is being raised. They want to say that the counting of past service is a facet of a UGC circular, and UGC circular, they would, although not very specifically saying so, but they want to convey a meaning that the UGC circular will not be applicable to us because we are governed by AICTE norms. That is the kind of contention on which that is the only kind of contention on which this appeal has been preferred. Your lordship will kindly come to the pleadings exchange in the previous round of litigation, that 2014 writ petition. Your lordship will kindly come to page 200. 174.
We'll admit it. Yeah, that I think we'll admit this again.
Lord, it's a long pending case, my lord. From 2014, this man is suffering, but because of the repeated nature of the stance taken by them, this is continuing. If your lordship wants to hear it for final takes up for final hearing on some other day, my lord, your lordship can fix it for final hearing on any day.
Yeah,
Convenient to your
we'll
lordship.
give you a fixed date.
Yes.
Heard Mr. SP Chaudhary and the counsel for the appeals. Admit. Who appears?
Only one respondent.
Only one is
Only one.
Mr. S. Datta, the senior counsel, assisted by S. Nuts, the counsel appears to be aware. When do you want to give a date convenient to both of you?
Well, any date after due vacation, my lord.
Release the matter for hearing on 23rd
23rd January.
January.
The interim order is to be continued.
There is an interim order. That's right.
Yes, stay order is there.
Interim order possibility to
Double
continue.
admission.
Double.
Next.
Item 8 for hearing.
Yeah, please. But here, this is a repetition challenging the ouster of the petitioner from a selection process for the post of copyist in the MSCT Nalbari. The petitioner was working as a copyist in the same establishment on a temporary basis. That lordship would find he started his services.
Who appears on the other? You are appearing and
For one and two, my lord. Sending counsel, what is High Court is also there, my lord. Like High Court.
High Court process.
finance,
Finance is also there. But after some time, I'll inform in the meantime.
catch hold of all this. High Court is a necessary party.
Yes, because it was under instructions of the Central Recruitment Cell that the petitioner was denied the advantage of the past experience. So they put that- put in-
Yes. After some time.
I'll try. Obliged.
Item 10.
Please, your lordships.
Well, in this repetition, there are two prayers primarily. If your lordship kindly comes to the prayer portion at page 16.
Just a minute, Chaudhary, who are there on the other sides? Finance.
Government in the finance and personnel, my government.
personnel. Yes, Das, are you agree?
Finance, my lord. There is separate standing council, my lord.
No, that we know.
Finance.
Ready? Ready.
Lordship, here, we have filed our affidavit, and in the affidavit, we have made a categorical statement that the rule was amended without taking into consultation the finance taxation department. And in one of the dates, earlier occasion, Lordship, personal department was directed to produce that record. Or
So who
it's,
appears for the personal department?
Let me after one week, the winter by. Right now.
Lord, in fact, I was trying to take your lordship to the prayer portion. There are two prayers primarily. One is, my lord, regarding challenge to a notification by which the SCS rules have been amended. And the second part is, my lord, praying for a direction to restructure the cadre strength of the taxation department. Now, after the affidavits filed by the, my lord, both the departments, it appears that finance was not consulted while making this amendment. The effect of the amendment was that a senior additional commissioner of taxes has been created in the, my lord, SCS. So, my lord, the tax officers association has come against that. Now, the finance department has said that without consulting us, this has been done. And the grievance of the petitioners were that the personnel department initially asked all the departments for giving suggestions for restructuring. And the restructuring proposal was, my lord, considered and it was sent to the government. Finance department in the affidavit now says that this amendment was done without our consultation and the representation has been sent to the personnel department for consideration. Now, although this amendment has been made way back in 2015, that has not been given effect to. The reason may be that, my lord, at that relevant point of time, the GST was not there. GST came subsequently, and our case is that you need technical persons, not administrative head over, that will only create more, red tapeism. Now, they have also not, my lord, given effect to it. And restructuring has also been, my lord, stalled. Therefore, my prayer before lordship, perhaps, my lord, they will not have any objection to that. That representation and recurring recommendation of the restructuring, that may be, my lord, a decision may be taken on that. So, my lord, we need not go into the challenge to the rules now. Because, my lord, they have also not for the, my lord, from 2015, they have not given effect to it,
Who is that letter?
my lord.
Who is that letter?
The later, my lord, the notification, my lord.
Yes. no.
Notification, your lordship will find at page 82.
80?
82. 82. This is a notification dated 9 September 2015 in exercise of the powers conferred by the proviso to Article 309 of the Constitution of India. The Governor of Assam is hereby pleased to make the following rules further to amend the Assam Civil Service Rules 1998. Then amendment of Rule 3, we are agreed by this. 2. In the principal rules, in Rule 3, for the sub-rule 1, the following sub-rule shall be substituted, namely, the service shall consist of the following classes and cadres. Then Roman 6, your lordship will find, sorry, my lord, no, junior grade, senior grade 1, selection grade, secretary to the government of Assam, commissioner and secretary to the government of Assam. Now, my lord, in the original rules, a part of it, my lord, original rules, your lordship will find at, my lord, page 19. There, my lord, the page 19, your lordship will find that additional secretary was there, that has been deleted. Now, my lord, if your lordship kindly comes to page 87, that is the, my lord, the notification which is under challenge. Now, your lordship may kindly come to page 89. List of posts, schedule 1, rule 3.2. Just at the bottom line. List of posts equivalent to and included in the cadre of service. Name and cadre, name of the post equivalent, so and so. Then your lordship will come to page 90. Selection grade. Additional secretary, number 2, senior additional commissioner of transport, 3, senior additional commissioner of excise. Number 4, we are concerned with senior additional commissioner of taxes. So this post was created, my lord. And the grievances of the petitioners are these, my lord. Although in the SCS there has been options are to be given, there are more meritorious and, my lord, whose position are above in the select list, they have opted for taxation department. I have given the instances. Now, those persons who are below them, they may have, my lord, reached that stage and they'll be on top of the persons who are working in the taxation department. Nevertheless, my lord, they are not giving effect to it till now. Therefore, my lord, the second prayer I am insisting, second prayer is that restructuring was done pursuant to the notification of the personnel department. My lord, elaborate exercise was done and a final proposal was given that your lordship will find at page 69 and 73. If your lordship kindly comes to page 69. This is, my lord, prior to that amendment of the SS rules. Subject, minus of the meeting of the cadre review committee. I am directed to forward here a copy of the minus of the meeting of the cadre review committee, finance taxation department, held on 27/3/2014 under the chairmanship of additional chief secretary. Further, you are required to kindly take immediate necessary steps on the actionable points which relates to your end. Then, my lord, a detailed report has been given. If your lordship kindly comes to page 70, the cadre under ATS rules 1995 as amended from time to time. Then the chart has been given. The committee opined that in view of the increase in the works and strength of the cadres under ATS rules 1995 as amended from time to time should be expanded. The committee asked City Assam to examine the matter and to submit report accordingly. And accordingly, my lord, a report was submitted. And, my lord, the prayer meeting that, my lord, that should be considered to be, my lord, implemented.
Who is the report?
A report your lordship will find at page 73 I was referring to. Then, my lord, the report is continuing there, my lord. It's a big report. Page 73, your lordship will find. They have got several recommendations. These are all recommendations. Ultimately, at page 80, your lordship will find. Page 80, last paragraph. The government is requested to consider this proposal for expansion of the cadre strength under the ATS rule 1995 as amended from time to time expeditiously and to the needful in the interest of the efficient tax administration. Because
But this was in 2014.
yes, ma'am.
Then after that, the amendment came in
Yes.
2015.
Yes. But the career strength of the, my lord, the taxation department, that was not done,
Hmm.
in spite of this report. So this report has to be considered and the government has to take a decision. It appears, my lord, they have taken a decision not to implement the, my lord, the amendment.
Is that correct,
No,
Mr.
my lord,
Das?
today I don't have any instruction. Can it be after 1 week, my lord? In the meantime, I'll get the proper instruction.
You come with proper instructions, is a.
Yes, yes, my. Immediately after my lord, the BU vacation.
It's only, I am asking for, my lord, consideration only, they'll pass an order, my lord.
And the issue is whether the amendment of 2015.
I am not
Has-
on amendment right now because,
no.
my lord, I have challenged the amendment of the rules
No, what Mr. Chowdhury is saying is that the amendment of 2015 has not been given effect to.
till date.
Till
my
date. Is that correct? This is what the court wants to know.
I'll get the instruction, my lord.
No, that, my lord, finance department knows that, my lord. That has no person has been appointed from
Who
SC.
appears for finance?
My lord.
Have you given effect to this?
in finance department, no.
Not yet.
No,
Finance
not-
taxation. Lord.
Therefore, my lord, my prayer before lordship is that you only consider these recommendations as has been given and pass an order. Whether you
Yes,
accept that
that's-
recommendation,
1 week, my lord, and immediately after the BU vacation. You'll come with the proper instruction.
Okay, you come with proper instructions.
my lord, in the affidavit, my lord, of the finance department, my lord, they have admitted that, they have stated that, my lord, very clearly. Paragraph 12, 11 and 12 of the, my lord, affidavit filed by the finance department, resolution number 3, shown by one Rakesh Agarwal. He didn't commit. Paragraph 12 at page 4, my lord, it says that with regard to the statements made in paragraph 18 of the petition, the deponent begs to state that the representation of Assam's Taxation Officers Association will duly forwarded to the Personnel A department as the grievance raised in the representation was related to the said department. Therefore, my lord, they have to pass an order.
Yes.
That is only my limited prayer, my lord. I am not asking anything more.
My lord, let it be 1 week, my lord. I'll come with. It might be also, my lord.
Okay, heard Mr. M.K. Javed and senior counsel assisted by Mr.
Z. Bashir.
G. Vaishal and a counsel for the petitioners. On request made by Mr. Endas, Leonard Government. List on. When?
Let it be next week, my lord. Why should they take? Because I am asking a very limited relief, my lord.
When do you want?
Okay, immediately after the 18th, my lord.
Let it be on 10th, my lord. Today is 4th.
18, my
18,
I
there'll
don't know,
be-
my lord. He's taking so much of
18,
time.
there'll be some difficulty.
Let it be 10th or 11th. 11th is a Thursday, my lord.
Yeah.
And 19th, my
19 also difficulty is there. Either you have it on 11th or 22nd, 23rd.
20.
The only instruction he needs is that, my lord, whether they'll consider our representation or not. That is the instruction. We can take over telephone. কি হবে না time লাগে? পুরো order head বলে তোমার দিয়ে consider it.
23rd, my lord.
of this.
Timing item 8.
Finance, they've all come.
Finance man, we have informed.
Guwahati High Court.
Guwahati.
Yeah. Are you all ready?
Yes, we filed the affidavit.
Gogoi?
Actually, I'm out of the record আমি বলে একটা order আছে records produce করে একটা order আছে
My lord, I have also, there's an order passed by the Sonvit Court on 15/9, 5/12, on 21/9, my lord,
1 minute.
21.
What is
for the record.
One second, see.
Hmm?
Yes, yes, please.
High Court party coming. But on 21/9/2023, there was an order.
29,
21/9.
21st of September, my lord,
21st of
last year,
September.
20
for production of records. My lord, I've written,
1 minute, 21/9.
lordship.
Respondents to produce records of the selection pursuant to the advertisement dated 13/11 available at page 39 to the writ petition. Respondents is submitted by outstaying the writ petitioner for having secured 43 marks with the cutoff marks was 50. In what manner the weightage was required to be given was given to the petitioner before outstaying him. And here what had happened is the petitioner was working on a temporary basis in the MSCT Nalbari, had participated in a selection process for the post of copyist. Matlab, he approached this honorable court earlier on an earlier occasion, apprehending that the due weightage for his experience of working from 2004 to 2013 may not be given to him, and this honorable court had directed that the weightage should be given to him. He appeared in the written test, my lord, and after the written test was held, it was at that stage that the selection committee took it upon itself to decide a cutoff mark, and they kept the petitioner out of the competition to go into the viva voce test. Now, my lord, when there were directions from this honorable court to give him the weightage for his experience, two questions would arise. Number one, whether the selection committee had to decide the cutoff mark prior to holding the selection process at all, and were they empowered to lay down a cutoff mark after the selection process is initiated. That is one part of the argument. The second part is, my lord, when there was a direction to give weightage to the petitioner, at what stage and in what manner the weightage was given to him. This was argued, my lord, on 21/9/2023. The honorable court wanted to see the records.
You have the records?
Yes.
Record was sent, madam?
The record, my lord, hasn't arrived as yet. I've written to the MSCT Nalbari through the Registrar General. But it hasn't arrived as yet. However, my lord, they stand in the affidavit.
But if they're ready
It's
to
very
argue
clear
without the
that, my
records,
lord, he did not qualify in the written, and the
Are
advertisement
you
is
willing
also.
to argue without a record?
I can argue, my lord, because
Or we want to see the records, since there's only the judicial order passed.
my lord, yes.
Yes.
So you have to produce the records.
Lordship. I will, my lord, short date, my lord.
Otherwise, in the affidavit in opposition, the dates are
Stands
there,
clear.
the resolutions are there, and from there I can show that it has been done after the selection process had been initiated. In that view of the matter,
But our Majumdar learned concept of petition. Request made by MS, S. Sharma,
Sharma.
S. Sharma, Leonard, Standing Council, Guwahati High Court.
Guwahati.
How much time do you require?
2 weeks, my lord, subject to the convenience of this
Just a
honorable court.
matter after 2 weeks. To enable her to produce the records as directed on 21/9/2023.
may I only pray, my lord, the selection is of the year 2013. Fixed date, my lord, and a last opportunity to them to bring up the records.
This matter. Today's for 23rd January. Huh?
Right.
And they would ensure the records, my lord, otherwise, I mean,
That's why
I'm obliged.
Item 11,
right? I go to.
Please, your lordship, before proceeding with this matter, I am appearing on behalf of B.D. Goswami, senior advocate. He is on bereavement, lordship. So kindly the matter may be listed after 2 weeks, lordship.
No, who appears for the petitioner?
I was searching, lordship, I have not found them, lordship.
Okay, none appears for the petitioner. On request made on behalf of Mr. B.T. Goswami and an additional advocate general, Arunachal Pradesh. List down after
2 weeks, lordship.
item 12 and 13,
The last occasion, there was an order, my lord, that this was the last chance given to them to start a hearing if they want. Well, here the government of Assam, we had introduced an act to provincialize the different educational institutions under which were running as uh, which were running Malad. Now, this repetition tries to challenge the entire act, saying that we are not in a position to provincialize the schools and we should continue to give financial aid to the private schools. We have filed our affidavit in the matter. There is no challenge to our powers to pass, to bring on the act into force. The only ground that they have taken is that under the right of children to free and compulsory education, we should establish schools and we should not provincialize schools. The Right to Education Act does not in any manner debar us from provincializing schools or taking over schools which are already in existence.
Problem is the conducting council has passed away
Yes, madam.
and some time was required in the last occasion.
That is on 1411 Lordship had observed. Perhaps a notice to the petitioners, my lord. I do not know whether the junior council should are taking up the matter in the due with due interest.
None represents the petitioner. Stop. It is submitted at the bar that Mr. N.L. Karmakar, uh, the conducting council has passed away. Stop. Accordingly, registry is directed to notify the petitioners for, for, for making alternative arrangements. Stop. List after 2 weeks, we'll do it. List.
Bless.
Item 14.
Well, pursuant to the order dated 16/2 passed in the present PI. Well, I have got the reports to show that, my lord, the authorities are, my lord, conducting the inspection of medicine. And wherever it is found that, my lord, they are not of standard quality, actions are being taken. I prefer some time to put this in on record, my lord. I've got the records, the reports, my lord. At least, my lord, the purpose will be served.
But Mr.
D. Google.
D. Goel and Council for Petition. Mr. B. Gogol, then Standing Council Health Department submits that he has received the report, isn't it?
Or materials, Lordship will see, my
That
lord,
he has received,
material.
that he has received instructions
Yes, madam.
and praise for how much time?
Well, that 10 days time, my lord, after vacation.
Praise for
Beautiful.
2 weeks time. To file affidavits. Praise allowed. Yes, the matter of 2 weeks.
Smile.
Item 15.
My pleasure, Lordship. Lordship, I am appearing on behalf of Mr. P.P. Datta, Lordship. He is out of station today, Lordship. The matter may kindly be taken up next week, Lordship, next Tuesday.
Not next week, my lord, after Tuesday, my lord. My lord, only one thing which I would like to bring to your lordship notice. There is an order dated 8/8/23. APSC should respond to that.
Who appearing for the APSC?
Mr. P.P. Datta is appearing, Lordship.
They have produced the records and the record reveals this. But they should also respond, my lord, what is their view in the matter. 8/23. Yes. May I forward a copy?
Yes. I can't see it. Yeah.
According to me, I mean, they should respond subject to what your lordship may say.
Yes.
11.
Okay, heard Mr. V.D. Das, then senior counsel, assisted by
Ardeka.
Article and counsel. On request made on behalf of Mr.
PP Datta Lordship,
P.P. Datta, then standing counsel,
APSC Lordship,
APSC. List on 11th.
11.
January.
I'm appealing for the state respondents in this case.
Oh,
Let it be on 24th.
Lordship,
23rd.
Lordship, I am for the private respondents here, Lordship. I have been the selected candidates, Lordship. Lordship, 24, Lordship, I have some difficulty, Lordship. Maybe after in the month of February, in that case, Lordship. The second week of February, Lordship.
First.
6th.
Lordship, can it be on, Lordship, 12th, your Lordship? 12th,
Well,
Lordship.
12th is the motion day.
Then 13th, your Lordship.
13th. 13th.
Much of
The APSC may respond to this.
Whoever, you have to respond to the order.
My lord, if your lordship's recording.
I'm not recording it, I'm just, next time there will be no audio.
Item 16.
May I please? In this case, my lord, I need some accommodation for today because this was made mention by the other side without prior information to me, my lord. And I've come today in the morning, so I need some time to prepare the case also, it's a big case. So after Bihu, my lord.
On request. Yes.
Earlier on several occasions, he took adjournment, my lord. We are pursuing the case, my lord.
It was hard on merit, my
My
lord,
lord,
once,
it was
once.
listed, my lord.
And
to
they have filed the vacation for vacation miss case for interim order vacation, my lord, that is dismissed.
Nowadays, my lord, listed matter is listed, my lord, 2 days ahead, my lord. So he is to be
I've come today.
sufficient, he is getting sufficient time. to
I've
get
come
prepared,
today,
my lord.
that's why today morning I have got it, my lord. So-
Okay, Mr. B. Procrastin and counsel for petitioner, request for some accommodation to enable him to prepare the matter. Accordingly, list on
Any date after Bihu, my lord, as your lordship declares.
25th. Oh, no, sorry.
On
Yeah. 25th January.
Obliged.
item 17 and 18.
Sir, I'm extremely sorry. Today, I could not prepare the case. I was in the midst of 3 hearings. So could it be done on Tuesday next, Lordship, this matter? Tuesday?
But otherwise, I should not object. But on so many occasions, time has been taken. My lord, kindly see the order.
In fact, it was heard in full and the final order was passed. Ultimately, the interim order was granted in our favor. On that day, it was actually a complete hearing was already done.
Judgment should have been delivered. Judgment was not delivered, only a stay order was granted.
In fact, full length hearing had taken place. Let it be done tomorrow also, Lordship. Tomorrow also I can do. If let it be.
Actually, there is urgency. Supposing, my lord, the review is dismissed, then I get my tenure, which is up to
This month.
only this month is left.
Is it a review or
It's a review,
read?
my lord.
Not a read appeal.
Oh, sorry. huh?
It's a writ appeal. It's a writ appeal.
Sorry, read appeal.
Writ appeal.
Read appeal.
On the request.
Let it be on Monday, Lordship, on Monday.
Learned Advocate General, Assam.
Actually-
List down. We'll have it on Tuesday then, a hearing date.
Yeah, Lordship.
My lord, no further adjournment.
9th.
No, in fact, we completed the hearing.
Okay, it is made clear there shall be no adjournment on the next day.
Highly obliged.
Item 19.
My lord, can I pray for some other date in this matter, my lord? I forgot to mention my junior, I have instructed them. I had to consent from the other side also.
We have some urgency, Your Lordship, in this matter because appellant number 1 to 5 have been promoted and 6 to 10 have been upgraded from the cadre of assistant engineer to the cadre of assistant executive
My lord,
engineer.
next Thursday, my lord.
Your Lordship, they are enjoying a wrong upgradation which has not been provided in the rules, Your Lordship.
Next Thursday, my lord.
made by
Next
Mr.
is the case.
List on 11th.
Lordship, in fact, if at all my presence is required, 10, 11 and 12, I will be out of station because of some personal reasons.
Then, my lord, after 7th of February, my lord. 13th February.
Any day thereafter.
13th of February.
My lord. Deep lord.
Item 24 from supplementary list.
So we're finishing early.
May I please, your lordship?
Yes.
Lordship, as per order dated 12/2023, the court is directed to produce the correct calculation sheet, lordship. But we are supposed to, it's likely to receive during the course of the day, the calculation sheet, lordship. So if lordship allows, it may be fixed on Monday, lordship.
Yes. But MS,
I does.
I does the concept what happened. On request to MS NDV, then CGC, list down. Monday,
Monday.
Monday is not the hearing day.
In that case, lordship, can it be taken up on 22nd of January?
23rd.
Lordship, 23rd,
Okay,
RPD Chaudhary, he is not available, lordship.
Okay, 22nd.
22nd. In the meantime, lordship, the calculation, if they receive, that may be shared with us so that we can also go through. Yes.